Good morning, this is your Kelso Report for Thursday, December 22nd, and I'm your host, Clark Kelso. We have a series of one-liners today, first in the area of civil procedure and jurisdiction. In Dow Chemical, Canada versus Superior Court, the 2nd District applied the United States Supreme Court's recent decision in J. McIntyre Machinery versus Nicastro in holding that a California court did not have personal jurisdiction in a products liability action over a Canadian company that manufactured a gas tank which ultimately was included in a speedboat that was sold in California and was in an accident where the gas tank exploded. Although the company was aware that its products might end up being sold in the United States, the company itself did nothing at all to avail itself of a California market and had no contacts with California. It sold in Canada. In these circumstances, according to the court, due process does not permit California to assert personal jurisdiction over the Canadian manufacturer on a stream of commerce theory. That's the theory that the Supreme Court rejected in Nicastro. Next, in the area of labor law. In Alleman versus AirTouch Cellular, the 2nd District affirmed summary judgment in favor of an employer against 2 members of a putative class action. The first employee sought reporting time pay for attending meetings at work and additional compensation for working split shifts. The court held that no additional reporting time pay was required because all of the meetings were previously scheduled, and the employee worked at least half the scheduled time anyway. No split shift compensation was required because on each occasion he worked a split shift, he earned more than the minimum amount required by the applicable wage order. The second employee actually released all claims against the defendant. The trial court had denied a motion for class certification without prejudice, and the 2nd District held that a denial of certification without prejudice was not an appealable order. Sounds to me like this case is falling apart on the plaintiffs. Next, criminal sentencing. In People v. Blackwell, the defendant was sentenced to prison for life without the possibility of parole after a jury convicted him of first-degree murder with felony murder special circumstances, burglary of an inhabited dwelling, and attempted robbery in an inhabited dwelling. The defendant was a minor at the time he committed the offenses. He was around age 14. But the district attorney elected to directly file the case in adult court. The defendant argued that the sentence violated Apprendi v. New Jersey because the jury never made a finding that he was over 14 years old, the age required for him to be tried in adult court. The 1st District rejected this argument since the defendant never objected to being tried in adult court, and the age of the defendant was not an element of any of the crimes of which he was charged. The court also rejected the defendant's argument that life without parole violated the 8th Amendment. Although the United States Supreme Court held in Graham v. Florida that a juvenile could not be sentenced to life without parole for a non-homicide case, Graham, by its own terms, did not apply to a homicide, and the case before the court was a particularly serious homicide involving special circumstances. Next, we have a summary judgment type of decision in Lona v. Citibank, where the 6th District held that the defendant bank failed to present evidence to support its contention that the facts were undisputed regarding the alleged unconscionability of a loan transaction by which the plaintiff refinanced a $1.5 million home. The problem was the plaintiff's income was only $3,300 per month, and the monthly mortgage payment was over $12,000 per month. Needless to say, he fell behind his payments almost immediately, and the bank foreclosed on the property, selling it in a non-judicial foreclosure sale. Now, the plaintiff sued to set aside the trustee's sale on the ground that he had been the victim of a predatory lender who took advantage of the fact that the borrower spoke very little English, had little education, and did not understand the details of the loan. Although the bank asserted that the loan documents had been properly signed, it did not provide any evidentiary support for its assertions, and the 6th District held that it failed to carry its burden of showing that there were no disputed questions of fact on the issue of unconscionability. I do think of some concern to the court was the fact that the loan documents indicated his income was more like $250,000 a year, instead of it being more like $36,000 a year. That's how he got the loan approved. Somebody was committing fraud here. And the problem for the court was, who was it? Was it the plaintiff, or was it the bank engaged in predatory lending? Next, a bankruptcy case. In Pioneer Construction versus Global Investment Corp., the 2nd District held that a contractor who filed a mechanics lien against property that was part of a bankruptcy had 90 days after the property left bankruptcy, pursuant to a trustee sale, to file its foreclosure complaint. According to the court, the 90-day limitation period provided by Section 3144 of the Civil Code for commencing a foreclosure proceeding was tolled so long as the property was held as part of the bankruptcy estate, and was subject to the bankruptcy law's automatic stay. Next, a government law case involving conflict of interest. In Eden Township Healthcare District versus Sutter Health, a healthcare district tried to rely upon the conflict of interest provision in Section 1090 of the Government Code to avoid its contractual obligations to Sutter Health, which gave Sutter an option to purchase the San Leandro Hospital as part of a larger transaction to secure Sutter Health's agreement to build a $300 million replacement for the district's aging acute care hospital. Section 1090 provides that members of a district shall not be financially interested in any contract made by them in their official capacity. Such contracts are void, and a violation of Section 1090 is also punishable as a felony. The 1st District held that Section 1090 was not violated here because the only possible interest one member of the district board had was because of his compensation as CEO of the entity that co-managed the aging acute care hospital with the district. The court applied the government salary non-interest exception to Section 1090 in finding that there was no conflict of interest, since his compensation from the government entity had no connection whatsoever to the transactions at issue. Next, in the area of banking law, in Firoyan Mazlumian versus Wells Fargo Bank, the 2nd District held that the holder of a line of credit at a bank is not a depositor at the bank for purposes of CCP Section 340's one-year limitation period for suits alleging wrongful payment on forged checks. The court held that the account was a loan account and not a deposit account, so the holder of the account was not a depositor for purposes of the statute defining the limitations period. And that's it for today's Kelso Report. Have a great day in the law.